application notice, a plan confirmation. It was available on the claims agent's website, and Judge Lopez said, no, that's not going to work here. I approved a process. I approved the opt-out process. They needed to receive the opt-out form, and if they didn't, they're not bound. And by the way, publication notice only works for unknown creditors. These are known creditors. A lot of these also are inmates, so I'm not sure what access they have to publication.
Oh, trust me, they have access. Judge Lopez knows they have access.
Is that the voice of experience?
You would be surprised what they can access. So, I mean, some of it may be AI, who knows, but they
Well, I know they file lawsuits against judges because Judge Lynn used to get those all the time. Say voluntary cases. No, but the point, I mean, the point is, I mean, really, is like, and so just to bring it back to sort of like the holding here is that, you know, when you have the opt-out, you know, form and process, that's okay, but you just have to kind of follow through and make sure that the person is actually served with it.
I mean, so this comes down to the Mullane, the Supreme Court decision that says if you could, with reasonable due diligence, find a way to contact the person, you have to give them actual notice. Here, it was a little tricky because we weren't talking about claims against the debtor that were being released. Obviously, the debtor knew who its creditors were and could readily serve those people. The issue was that their settlement party, not a debtor, had claims against them that were not necessarily asserted against the debtor. So the debtor really didn't have a way to contact those people. And so when you end up with a service list, you serve the plan on the people on your service list, there was a gap in the parties that needed to get notice. And
what I report is I can only authorize a release of claims between, there has to be some connection to the case, right? So if somebody just wants a release of someone who has nothing to do with the case, well, you know, forget about it. It's not worth the paper it's printed on, and that's what I'm enforcing at the same time. The other point is, there were many creditors who were in active litigation with the debtor at the time, and the party, right? Because it was a Texas two-step case, so you know, the real question then becomes, the burden then becomes, you know, there's a known creditor, right? And so publication isn't going to work. So let's just start, so then we have to start analyzing the form of service that one received, and just because there's a certificate of service, you get the presumption that the mailing was right? But then there's still kind of, someone can still come back and say, hey, I'm a prisoner. You knew who I was. So publication isn't going to work, and we've been actively litigating. The lesson, first of all, with the AI is if you just actually open the case and read it, you find out really quickly if the case existed or not. I don't understand how there's hallucinations if lawyers actually read cases. That's point one. Point two is when it comes to this service, cases are incredibly expensive these days, right? And so everybody's trying to find a way to minimize costs. And one of the areas that we're seeing it is with service. And it's not saying people are doing anything wrong. They're just trying to save costs. And so, but if you really want someone to be a part of a third-party release, a consensual one, you got to make sure that the address works. And sometimes, you know, you got to go old school and make sure that you send it to 2 different places to make sure that they got it in the first place. Because if not, you're going to run into the square problem is that someone's going to come in and try to ask the bankruptcy court to enforce it, or a court of another jurisdiction to go enforce it, and they're going to look at that certificate of service, and it's either going to work or it's not going to work.
And I think it kind of raised another point that I wanted to make is that, you know, I think sometimes we refer to judges as like opt-out judges, like these judges are in favor of the opt-out ballots and some are not. But like Judge just said, like, there are requirements. It's not appropriate in every case. I think even the Purdue lawyers would tell you, like, it's only in the exceptional circumstance when there's some sort of value being unlocked, where there's a nexus with the debtor. I mean, there's requirements, right? And so there was one case which Judge Mullen did not approve because it didn't meet the requirements. All of a sudden, Judge Mullen's not an opt-out, not a bad opt-out. Like, that's not right. That's not, you can't paint them with the broad brush, which actually leads to the next case. And I'm not going to talk about it too much. Well, actually, so we're going to...
No, it was an interesting, I think it is one of the first post-Purdue really thorough decision saying why opt-outs work. And it was, the context was, I think the U.S. trustee was arguing that, you know, the state laws differ, and, you know, Judge Glenn kind of shut that down and said, well, bankruptcy needs to be a uniform uniform system and trying to understand what is consent in New Jersey or Vermont or Nebraska or all these other states where the victims are, the creditors are, just, it doesn't work, it's impossible to govern. But meanwhile, we understand what notice is required, as we talked about, like if you can give actual notice to these individuals, you should, and you have to for it to work. And so Judge Glenn kind of came down on this is what you did, effectively a roadmap. And I've been involved in cases even since Golinas, which was in May, where judges are starting to align with that an opt-out can work, again, if you give the proper notice and you give the right opportunity, and then you can build a record for, first of all, showing that creditors actually accepted or opted out, they checked the box, or they went to the website, they did whatever they did. You built the record to show that notice worked. And so under that circumstances, with again a uniform system for notice and consent, you can prove that we're not in the Purdue world of non-consensual third-party releases, but this is actually what consent looks like.
The only thing I'll mention is I've noticed a cite to Smallholt in the opinion that I think is incorrect. It says that Judge Goldblatt held that you needed to opt in order for the third-party release to be appropriate. You needed to opt in, and that's not what he held. There were two types of classes in that were at issue, and one of them was a class where if you accepted or rejected the plan but didn't submit the opt-out form, then you're bound. So he actually approved the opt-out for that class because there was some action. In his view, there has to be some sort of action that manifests. It's almost like when you're clicking through on your whatever website and you accept something and you click through, like you don't have to accept every single thing, but he said, look, if you're accepting or rejecting a plan, like that's evidencing that you saw it and you received it and you didn't submit the form, so you're bound to the opt-out there. So I saw him last week and I told him I'd try to vindicate his name as much as I can.
Well, I think we call it click wrap, and it might work. All right, is this Brian, is this yours or Christina? Christina, tell us about Rashidi.
So Rashidi is a Northern District case where Judge Larson basically talks about in Chapter 20. A debtor filed a Chapter 7 bankruptcy to liquidate her debts. She had a Chevy Impala. Her statement of intent said that she was going to reaffirm that debt. Creditor sent out the reaffirmation agreement. Debtor's counsel never got it back, never heard back, asked again, didn't get anything back. Debtor received their discharge. And then 7 days later, went and filed a Chapter 13 bankruptcy that crammed down the interest rate significantly on this vehicle. And Judge Larson basically explains how the state lifted because there was no attempt at showing of good faith by the debtor. They were trying to abuse the process. This is another case where I think that if you talk to your debtor ahead of time with the goals of what they want before they file, you can avoid this type of situation. In the second case, there is no discharge available to the debtor. So if you are counting down a vehicle and at the end of the case, they're still going to owe that money on the vehicle. So it's kind of like an extended lease. Is that what your debtor wants? The debtor could have probably reaffirmed the vehicle, attempted to make a couple of payments, and then if they weren't able to, they could then file a Chapter 13. That would have been an attempt at good faith. I would see these a lot, especially when the SBA was collecting loans where debtors didn't qualify for a Chapter 13 because of the debt limit. And they would file a 7 to wipe away that obligation, and then they'd come back and they'd file a 13 to try to get current on their home. I would just really caution to look at what's going on, because if they're behind on their home, they can live to stay while they're in the 7, and they can lose the home before, if that's the goal. So they're a good tool, but I would just caution the use, and I kind of like how Judge Larson went into the good faith of doing one of this.
All right, I want to talk about fresh acquisitions for a moment. And this case is about post-confirmation litigation trust, governance, and disclosures at the time of the plan about what's happening next. And most importantly, has anyone ever heard the expression FAFO? Does anyone know what that means? If you want to find out this much, if you need to... Let's not call on his partner for this. Basically, so let me set up the facts. There was a post-confirmation trust set up by the committee in the committee's liquidating plan. An individual named Mr. Gonzalez, David Gonzalez, was appointed as the trustee. He had been the committee's FA. He entered into a post-confirmation litigation funding agreement It was not approved by the court. It was not known by the court until 2 years later, and created some chaos. And let me kind of walk through the facts. First, this was the Buffets Restaurants Chapter 44. If anyone's familiar with that, it was the fourth bankruptcy in like 12 years. Ultimately, all the restaurants were closed except for one brand. Those were sold along with the other intellectual property to Dave's Barbecue, or I forget the buyer. But what was left was some cash and some causes of action. And the committee had spent a lot of time investigating claims against the insiders and really wanted to pursue those. The debtor thought, hey, it's just cash causes of action. This is well within a Chapter 7 trustee's wheelhouse. Just convert it, let one of the Dallas panel trustees handle this. They're more than capable of doing this. The committee said, no, and I'll quote, we are extremely familiar with the debtor's corporate structure, and we spent a lot of time investigating it. We want to pursue these claims. We're better suited to do it. Judge Jernigan explains that she ultimately approved the plan, and then her words, long-awaited lawsuit was filed 9 months post-confirmation. It was 71 pages long. It included 22 named defendants as well as unknown John and Jane Doe's and ABC corporations. It had 27 counts, more than there are letters in the alphabet. And Judge Jernigan, at the first blush, she ordered severance of the lawsuits, and the details don't matter on that, but this is when the bad stuff happened. 10 months after Judge Jernigan ordered a severance, the trustee finally did file the amended complaints in the new lawsuits. And then another year and a half, about 18 months later, is when she discovered that the case just wasn't progressing, so she called a status conference, and in her words, by accident, discovered this litigation financing agreement. And the details of that are less important, but the opinion lays out some important math facts. And because Judge Jernigan is an accountant by nature, she gave the example. She said, for example, for this litigation funding, because of this litigation funding agreement, if the trustee were to recover $10 million, that would only net like $500,000 to all the guts, which seemed problematic to her. She said, for there to be a meaningful recovery along the lines that she had thought was proposed in the disclosure statement, the trustee would ultimately need to recover $30 million, which didn't seem like that was going to happen anytime soon. And of course, and this is where it got really problematic, she said none of this was disclosed to her at the confirmation stage. Nothing was in the disclosure statement, and this becomes important because she approved the disclosure statement. And so here's the legal analysis, and let me give you the result first. She removed the trustee. She ordered that the trustee needed to be removed. This is a post-confirmation plan trustee. And she said, first, let me talk about subject matter jurisdiction. She cited Genon and Galaz, which
Are those still valid now?
don't know. We'll wait to be seen. And I should note that this opinion is on appeal, so we may find out very soon. But under Genon and Galaz, a bankruptcy court maintains jurisdiction, even post-confirmation, of its prior orders. And here Judge Jernigan concluded that she'd been hoodwinked, her words, by the disclosure statement, which never mentioned the possibility of a litigation funding agreement. Also, she noted that the liquidating trust agreement didn't even authorize the trustee to enter into this kind of a funding agreement. And it had no oversight committee, which was extremely problematic to her. And so she quoted, in a really good decision, one of Judge Posner's decision, I think it was in Ray Bryson, that discusses the concept of litigation judgment. And it was a missive from the 1997 Henry Bryson decision, where she concludes that, in this quote, judges must therefore be vigilant in policing the litigation judgment exercised by trustees in bankruptcy, because a liquidating trustee doesn't have the same inhibitions that an operating company might have, because you don't want to sue vendors, customers, counterparties, things like that. And here, considering the lack of disclosure, the dishonesty, and just basic math that Judge Jernigan did, she concluded that Mr. Gonzalez had not exercised reasonable business judgment or litigation judgment, and her exact words were, I'll read this quote, transparency is the hallmark of bankruptcy. As the court indicated at the June 5th, 2025 status conference, the court is having trouble seeing how the juice will ever be worth the squeeze here. It would appear that the unapproved litigation funding agreement has ensured that. So the lesson here, again, disclosures in your disclosure statement about what might happen as litigation unfolds. I mean, I know it's hard to predict, but at least give yourself that room and be honest. In a liquidating trust like this, an oversight committee is probably necessary. And for goodness sake, Omar, if you intend to fluff around in Judge Jeremy's court, be prepared to find out.
I tend not to go there.
All right, Brian, tell us about Keith, please.
Speaking of problematically not disclosing things to judges, this is a case, Bonniers, it's granted cert to the Supreme Court, and it deals with judicial estoppel. So the Fifth Circuit, when judicial estoppel questions coming out of bankruptcy-related situations get to the Fifth Circuit has routinely applied against a debtor at least, judicial estoppel say, if you didn't disclose it in the bankruptcy, you can forget about monetizing it somewhere else, as to the debtor at least. The case law allows for a 7 trustee to not be prejudiced by that 13 trustee as well. But anytime the debtor has showed up in the Fifth Circuit arguing, I should be able to monetize this, even though I didn't disclose it in my bankruptcy case, the Fifth Circuit says, no, you don't think about it. So this is a situation where the Chapter 13 debtor files in Arkansas in 2019, gets a plan confirmed in 2020, in 2021 gets in a vehicle accident in Mississippi, and in Mississippi, mind you, a different circuit, Mississippi Fifth Circuit, Arkansas with FDA, files a personal injury lawsuit in federal district court. Claims to have told the bankruptcy attorney in Arkansas about the personal injury claim, but it's not disclosed in the bankruptcy until April of 2023, a month after the defendant files a motion for summary judgment based on judicial estoppel, saying this debtor got a bankruptcy case, it's been sitting there for 2 years since the accident happened, debtor has not disclosed it. Oh, and by the way, the debtor has amended schedules 3 times in that period without disclosing the personal injury claim. The district court grants summary judgment, so the debtor responds by asking the court to alter or amend the judgment and attaches an affidavit from the Chapter 13 trustee's staff attorney saying, well, in our state, Arkansas, it's actually pretty common for debtors' counsel not to disclose these causes of action until they're about to either be settled or tried. Basically saying, this is what we do in Arkansas.
It's pretty authoritative.
Well, it raises some very interesting questions that the court doesn't really deal with, doesn't need to in this context. But so the summary judgment stands, it goes up to the Fifth Circuit. This Fifth Circuit goes to the judicial estoppel elements and said, look, they're all here. This was not an inadvertent failure to disclose. The debtor knew about it, had time and opportunity in the bankruptcy court, had 3 amendments to the schedule in which he does not make these changes, etc., etc. So the debtor cannot monetize it. Judge Haynes writes a concurrence saying, well, actually, I think that really what should be done in these situations is that bankruptcy court should be the one that gets to decide whether or not judicial estoppel applies relating to a failure to disclose in bankruptcy, which is another quirk about the system. Is I think if you end up in the district court arguing about whether or not judicial estoppel applies to the failure to disclose in the bankruptcy court, you're going to lose. You might win in the bankruptcy court. We have a shot in the bankruptcy court, because you might be able to convince the bankruptcy court, hey, look, inadvertent, no prejudice of creditors, for instance, right? Which is another point that Judge Haynes raised. But it's one that the Supreme Court has granted cert on because the other circuits they've at least applied this test a bit more leniently. One thing that wasn't addressed in this case at all, and I don't understand, as far as I can tell, at least the Chapter 13 trustee made no effort to intervene. But there's no explanation or discussion at all of, well, I should the 13 trustee have been allowed to step in. And the thing that makes it the weirdest is that affidavit from the staff attorney for the Chapter 13 trustee. And I couldn't tell if they were just waiting because they didn't think that judicial estoppel would be applied like that. But in any event, it's going to the Supreme Court, which presumably will give a little bit more clarity on how to apply judicial estoppel for failure to disclose in the bankruptcy context.
So just a quick practice tip on that. If you are amending anything for your debtor or doing a modification, just attach a 1 sheet to whatever you're having your debtor sign that asks them, are you part of any litigation? Have you hired an attorney? And have them actually sign, right? None, yes, and then that way later if they come back and they want their money from the AT&T lawsuit that they joined because they saw it on TikTok and they can't get it, you can be like, this is why you can't get it. You didn't tell me about it when I asked you about it. And you protect yourself, and you protect your debtor and prompt them to let you know what's going on.
Christina, at cocktail hour, I want to hear whether you would have given that kind of a letter. Normal, we do this all the time. All right, Omar, round 3 is going to be a lightning round. So can you summarize this 71-page opinion 2 minutes or less.
I cannot. I cannot. I'll just tell you, there's a lot of good stuff in here. This is a really long opinion from Judge Larson. It's really good. If you represent trustees, if you represent creditors committee, I commend you to read the decision. It's,
Tell us the core holding.
yeah, so well, there's preference issues, so she goes through the elements. There's some really interesting things I hadn't even thought about there. But then also with liens on commercial torts and trademarks, and how do you avoid the foreclosures, whether they're proper or not. There's also equitable subordination, recharacterization, constructive fraudulent transfer, validity of foreclosure, partridge in a pear tree. Like, there's a lot in here, and there's no way that I had picked a few to talk about, but don't have enough time. But all I say is, like, y'all should go read that opinion.
Is this yours, Brian?
Yeah, this is
You want to try to do the same?
it's a fun one to read. A receiver requesting administrative claim in the bankruptcy case that would have eaten up all of the money in the bankruptcy case, ended up getting Lodestar instead of the 25% that receivers typically get. Fun fact, the receiver puts himself on the docket as professor.
Oh, good.
Please, so,
I'm also a professor. I'll do the same real quick. Roman CAD, I think we'll hear more about this in the mass tort panel tomorrow, or if not this case, the concept. This was the court approving a buyback and sale of insurance policies to settle basically with the insurance policy. Remember OGA charters in the Fifth Circuit says insurance policies are property of the estate, even if the proceeds don't really belong to the estate, but when you have more claims than you do up proceeds, it's really up to the debtor or the trustee to kind of marshal those and figure out the best way to maximize those for even distribution. So good decision out of the Judge Glenn in the Southern District of New York. Read that one. And we have a lot more to cover, but no time. So thank you all for your
I'll just say centrist.
That's it. Let's take our time with one more. If you have questions for them, especially what Aaron was referencing, what it means, find them at happy hour or maybe the Young Lawyer Committee reception this evening. While this panel is vacating the stage, I'm going to ask Kat Hopkins from the Bankruptcy Law Section to come up to present the Bankruptcy Law Section Scholarship.